current demographics show us that our workforce is aging, our clients are aging, our lawyers are aging. I used to talk to many clients about the idea of retirement and transitioning practices, and the reality is that in many, many situations what we're actually talking about is the pending death or disability of key partners within firms that necessitate succession planning. We're also talking about issues of client retention. Hello, I'm Michael Moore of Moore's Law in Milwaukee, and I help lawyers and law firms around the state and across the country achieve professional success. Our topic is succession planning, and I've found across my client base this to be a very dynamic topic that's very much in the news these days and very much of concern for many, many firms. This is primarily because 77% of senior partners surveyed do not want to discuss succession planning, do not want to discuss transitioning into the ends of their career or transitioning their client base. And unfortunately, 45% of lawyers regard succession planning as too difficult of a topic to bring up, uncomfortable topic to discuss. It's very important that law firms begin to concentrate and structure effective knowledge transfer strategies, both for the development of the next generation that's going to lead the law firm, but also to handle your clients, to retain your clients. So you're going to need to do both things: knowledge transfer for development potential, knowledge transfer of client relationships to retain the revenue stream and the relationships that those clients provide. We need to ask questions of who are our current leaders? Who could our potential future leaders be? How are we going to develop those leaders? Frequently, law firms need to concentrate on their structure so that they provide opportunities for leadership, such things as membership on committees, membership on tactical teams that are going to tackle implementation of a specific initiative. These are opportunities for younger lawyers to be given leadership opportunities and for the more senior management team to evaluate that. The next important part of this comes from the fact that the professional rules of responsibility clearly state that there is an ethical duty to approach succession planning at some point in your practice. It's spelled out specifically for solos. We'll get into that in a moment. But it's also, by the nature of the words, inherent in firms to have succession planning in place. So, for example, if we look at Rule 1.1, competence, the duty of competent representation suggests at a minimum that upon death or disability of the attorney ensures that someone will step in to provide continued representation on the matter or a client. 1.3, diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. Commentary 5 makes it clear that to prevent neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence requires that the sole practitioner have a succession plan in place. Inherent in that language is the fact that it implies that a firm would logically be prepared to step up and take over that partner's clients or that lawyer's clients in the event, again, of death or disability. So succession planning is woven into the commentary. Under 1.6, confidentiality, the commentary 16 provides that a lawyer must act competently to safeguard information relating to the representation of the client against inadvertent or unauthorized disclosure. Arrangements need to be made prior to the attorney's death or disability to form a succession plan to make sure the client information remains confidential, even when that transfer occurs. This also flows over into 5.3b, responsibilities regarding non-lawyer associates or assistants. Commentary 2 confirms that lawyers with management authority within a law firm are required to make reasonable efforts to ensure that internal process and procedures are in place to make sure that everyone follows the rules and acts professionally. So inherent in here as well is the fact that should something happen, we don't want that period of chaos where confidential information might get inadvertently disclosed because there is no plan and people are not sure what to do. So that becomes very important to remember, that while we may say, gee, there are some good reasons to have succession planning in place, there is also an ethical obligation under the rules to say that. Law firms have to create sustained adaptability for their future and the success of those that remain after the transition of succession planning. The 4 key areas we talk about are: how is your firm prepared to handle change? How is your firm going to bridge the generation gap? Diversity is something that is coming, moving through the demographics of the United States population. We are becoming more and more diverse. The decision makers are becoming more and more diverse. Therefore, your client base is becoming more and more diverse. That requires us to have more and more diversity in our representation among our ranks if we're going to stay competitive. The last piece, obviously, is technology. Technology is moving rapidly, the commoditization of law, also things like LegalZoom and Rocket Lawyer and Law Pivot. There have been conferences recently from the tech sector where they are actively talking about disruptive technology. And that's technology that is going to radically change the practice and delivery of law. So that becomes another very important part of your succession planning, to make sustained adaptability something in your firm dealing with these 4 areas. It's all very fine and good to say that, yes, you're right, we understand, we need to do something. Frequently as lawyers, though, we procrastinate. And frequently as law firms, we procrastinate to the nth degree, exponentially. We try to reach consensus, we never get anything done. I have clients that call me up after 2 years and say, we still haven't moved forward. And we need your help because we have to move forward because, of course, now we're 2 years further down the road. Often our firms especially are geared to measuring hard things like billable hours, revenue production, things like that. It doesn't allow us the latitude to take time to think and develop and plan for the future. The things that are required to build succession plans and execute succession plans, the things that are required to develop young lawyers, these are the kind of things that we need to make space for. So we want to do what we call a bias for action. And a bias for action means that doing means learning, and learning means we may make mistakes. We've all been through that when we were younger, and we know that to be true, and now we need to engage in that once again. Enlightened trial and error will outperform flawless intellect every time. And so that's what we're trying to engage in. A knowledge advantage that many of you may have means nothing unless you have an action advantage. Let me warn you finally with one last thing, and that is that frequently partners say to me, well, I know someone at a firm where they're doing this, or I read a book about they're doing that. Merely copying existing things are probably not going to work. Frequently we find that unique situations are required because law firms, each and every one, has a unique culture, unique practices, unique individuals. So we need to be cautious about just merely copying. We need to take the time to invent a unique solution that will give us a positive base for the future.